Welcome everyone to this market briefing, and a little bit of housekeeping before we get started, and then I'll quickly introduce our presenters and then hand over to them for the main event. So, in terms of housekeeping, the ask is please can you keep cameras and microphones off, because it helps us with the technology. And I think, as I usually say, we really would like to stay with you for the duration of the presentation. So yes, that would be much appreciated. Questions, if you could pop those in the chat, and I'll keep an eye out on that, so we can ask those as we go along, if that works. But there will also be question and answers at the end. Also to remind you that I think Zoom usually does a marvellous job of telling you that it's being recorded. So the session is being recorded, but that does mean that afterwards you'll get a link to the recording and a copy of the slides. So if you've got colleagues that haven't been able to attend, you can forward it on to them as well. And last but not least, the session is accredited for CPD by the CII, so you can record this in your training learning logs if it meets with your development needs. So that's all of my do's and don'ts. Also encouraging you that there is a little bit of interactivity in this one, so there is some looking for some feedback on. I say feedback. It's a nice way of saying there's a question and we're looking for an answer. So there's a little bit of a quiz in here as well. So yes, please join in. So that's my bit over. I'm pleased to welcome Aspen and Weightmans as well in support. So we've got a partnership today, a double act. So happy to introduce Richard. Asian. Yeah. Apologies. Who will do, as I've evidenced there, will do a much better job at introducing themselves. And we are looking at environmental liability. So I'll hand over to Richard.
Thank you. So welcome. Yes, as Alison mentioned, it's an interactive session, so there's a few polls and questions as we go through. For the learning objectives, we have a few things we're going to cover today, which are talking about essentially the limitations in sudden accidental pollution and how gradual pollution can help clients with coverage gaps and uninsured exposures. And we're also going to talk about some of the legal developments and where pollution litigation and law has gone to. So to start, why environmental insurance? So environmental insurance really should be called pollution insurance. Pollution is the trigger, pollution is the insured peril. All clients have a pollution exposure, and a lot of those clients either know about their pollution exposure or don't really understand their pollution exposure and don't understand the coverage gap of their insured risk for this pollution exposure. I think when you look at the MGA space specifically, other countries, Canada and other parts of the world, are more advanced than the UK in terms of the take-up and the availability of environmental insurance. So our scope and our headroom to grow is really those clients and businesses that don't currently buy environmental insurance. So the first question, the first interactive poll is, so what is pollution? How would you define pollution? So we've got a few different options there. Something where it shouldn't be waste or sudden and accidental event.
So we're sitting at 50-50 at the moment between something where it shouldn't be there and sudden and accidental event.
So exactly that. Pollution in its simplest form is something where it shouldn't be. I think that the more technical definition is pollution is a change in state. It's the introduction of substances or energy into the local environment that causes a chemical change. So an oil spill is quite an obvious example. The oil changes the state by being present in the soil. Energy examples could be things like radiation and electromagnetic fields. So what was interesting about that poll is that a few people fell into my kind of the insurance way of thinking to talk about pollution and immediately go to the that insurance definition of sudden accidental event, whereas that's more insurance and a trigger than pollution itself. So I think the next slide has a nice definition of pollutant on it. So exactly that. So pollution is something that is somewhere it shouldn't be. And when you look at a definition of pollutant from environmental policy, the language is different, very different from a public liability policy, and kind of maybe intentionally broader in scope. As per the poll, the other kind of red herring is included in there. Waste is in there, and waste is in the definition of pollutant. But going back to that original kind of overarching point that pollution is something where it shouldn't be, waste is only a pollutant if it's not where it should be. So, but just like the poll, when you ask someone insurance about pollution, the conversation normally moves to these words of sudden accidental versus gradual. So the next slide shows. So this is an example of a typical pollution coverage in a public liability policy. So the coverage in a public liability policy is, as you may know, is an exclusion, and it's a pollution exclusion with a right back for certain coverage. So the wording here says pollution is not covered unless if there's a sudden, identifiable, unexpected event which takes place entirely at a specific time and place. So examples of scenarios that would satisfy this condition would have to be kind of just an immediate catastrophic failure of something, a tank, machinery, a dam, that kind of thing. So how does that then compare to an environmental policy? So the next slide has the comparison. So there's the definition of pollutant. Again, we have all of these different types of contaminant that could be considered a pollutant. So, and then you have the pollution incident. So the environmental wording defines pollution incident, introducing all of this additional language: discharge, emissions, seepage, migration, dispersal. None of these have that concept of time in it that you see in the sudden and accidental example. So here we're talking about a pollutant that is subject to a discharge, emission, seepage, so not naturally present in the environment in a concentration or the amounts discovered. So again, going back to something that is somewhere it shouldn't be. So the next slide. Aidan.
Yes. Well, good afternoon, everybody. I'm Aidan Thompson. I'm a partner at Weightmans, specialising in environmental liability, particularly for insurers. And the question that I'm going to deal with first is, when does pollution have to be cleaned up? And I think we've got a little question for everybody.
We have. It has just been launched,
okay.
so I will.
And the questions. So we've got. When does pollution have to be cleaned up? When an environment agency, a regulator, enforces it. When there is property damage, or when there's a third-party claim. What does everyone think about that? How are we doing?
So at the moment it is 75% for the Environment Agency and 25 and
smooth.
It's going more towards Environment Agency and less towards property damage.
Right. Well, that's good. That is an encouraging answer. Because if we move on to the next slide, please. Right. So environmental regulators do have very significant powers to enforce the cleanup of pollution. So yes, you know, where there is property damage, it's civil law. Where there's a third-party claim, that might require pollution to be cleaned up, but it's much more likely that the regulators will get in there first, and they will ask for contamination to be cleaned up. There are lots of different regulators. The Environment Agency is just one, but local authorities also play quite a role in this, in cleanup as well. So there are a variety of different regulators that might require cleanup, and they tend to require cleanup under these powers under 5 different regimes. And there they are on the left-hand side of the slide. We've got all sorts of cleanup regimes in this country. We've got the contaminated land regime, the water pollution regime, the environmental damage regime, there's a waste regime, and there's an environmental permitting regime. Now, you've got to be a bit of a nerdy type to know the ins and outs of all of these, but they all target particular bodies or particular individuals that might be responsible might be responsible for the pollution. It's not always going to be the polluter itself that has to do the cleaning up. Sometimes it's just the owner of the land. Sometimes it's the person who didn't cause the pollution itself, but knew that it was happening or was going to happen. So a variety of wide net of people can be the target for these cleanup powers. But there's always got to be a cleanup intervention trigger. These regulators can't just order things to be cleaned up willy-nilly. There's got to be some sort of benchmark or a sort of a threshold level of contamination under each of these regimes before they can be cleaned up. For example, under the contaminated land regime, what the Environment Agency is looking for is what's called a significant contaminant linkage. So they're looking for a source of pollution, then they're looking for someone or something that could be affected by it, and a plausible way by which the pollution can reach this receptor. You know, without that requirement, the cleanup powers can't be engaged. And the objective here, for all of these cleanup powers, is to clean up. It's not about compensation or paying damages for people who are injured or who have suffered a loss of amenity or anything like that. These powers are all geared towards remediation, so that the risk that the pollution sort of carries is very much mitigated or removed. That's the idea behind all of these. And in the final column of this slide, you'll see that all of these cleanup requirements are imposed on a strict liability basis. Generally speaking, there's no option for the people that are targeted under these regimes to say, well, you know, I reasonably did not know about that this was going to cause a pollution problem. You know, I took all of the due diligence steps that I should have done, and yet this still happened. You know, I behaved reasonably. This was very, very unfortunate accident. Generally speaking, under these cleanup regimes, they are strict liability, and these sorts of excuses won't get you out of the woods. So that's all on these cleanup powers of regulators, and I think you'll agree that they can be engaged very quickly on a strict liability basis, and require those that are targeted to do quite a lot of work. For the next slide, please. Okay, so the next question, the next question is whether this pollution that we've been talking about, that Richard's been talking about, or it constitutes damage, property damage. Is pollution property damage? And the question really, it's a yes or no. How are we doing?
So,
We've got 1, 2.
It's
moving.
So
There's
at the moment,
excitement in the room here.
it's about 3/4 yes. So something like 75% yes, 25% no.
Well, the answer is more. Certainly, I mean, is no. Pollution does not always constitute property damage, and this is one of the things. It's very important to bring out here that a piece of property, a piece of land, can be really quite extensively polluted. But don't assume that that will automatically be property damage at law. That's the sort of thing that might cause a public liability policy to be triggered. Property damage is permanent physical loss of or any permanent change in the physical condition of material or tangible property that impairs its value or usefulness. Now, pollution may have to be cleaned up. It may attract cleanup under one of the regimes that I've just spoken about, but it might not constitute property damage. And that means that, of course, your public liability policy to cover you for property damage, covering you for property damage, isn't going to be a lot of use. The environmental damage regime is an interesting one. That's one of the regimes that I mentioned before. The environmental damage regime covers for all sorts of different kinds of environmental damage, including damage to biodiversity. But there's very little prospect of damage to biodiversity being classed as property damage at law, the sort of property damage that gets covered under a public liability policy. So very important to understand that there is a disconnect between the legal definition of pollution and environmental damage and a general liability policy's definition of property damage. In short, there's an awful lot of pollution that you might be, or damage to the environment that you might be found liable for that is not going to fall within a general liability policy. And just to illustrate that, I just want to talk a little bit about the 2006 case of Bartoline against RSA. Bartoline had a problem at one of its facilities, and chemicals there'd been an incident, and pollution had entered into the ground and local water courses, possibly as a result of the extensive use of firewater and other things by the emergency services. The Environment Agency obviously has required cleanup under one of the regimes that I mentioned earlier. It required cleanup, but in this case, the Environment Agency decided to do the cleanup itself and charge Bartoline for the costs. Bartoline before paying the costs, then said, well, went to its insurer, RSA, and said, we've been sent this bill by the Environment Agency for its cleanup activities. And the RSA said, well, we don't think that a bill from the Environment Agency under these circumstances really constitutes a legal liability for damages, which is what our policy covers. This is not really a claim for damages that the Environment Agency has brought against you. This is a statutory debt, really, that's owed to the Environment Agency, not really what your policy is for at all. And of course, the whole thing went to court, and the court sided with the defendant, RSA. It said that under this policy, a legal liability for damages, which is what is covered, doesn't include this sort of statutory debt owed to the Environment Agency. So, to cut a long story short, there was this was a pollution incident had occurred. Significant costs were being claimed from Bartoline, and the general liability policy didn't cover it. Can I have the next slide, please? Now, at the moment, there is. I'm just going to illustrate some of what's been said in the context of a brewing issue at the moment relating to PFAS. PFAS is a group of fluorinated chemicals. Can I have the next slide, please? Now, these chemicals have been used for many, many years in all sorts of products because of their water and grease-proof properties. They've been used very extensively, really since the time of since shortly after the Second World War. As a result of having been put in lots of products, they're very common in our environment now. They're everywhere. They've obviously, as they've been used, as they've been consigned to waste, they've got into land, they've got into water, and they're very common. And unfortunately now, PFAS are considered to cause cancer, or certain types of cancer, or should I say certain types of PFAS are now believed to cause certain types of cancer, which is not great considering just how it's everywhere. Now, in time, rather like with the asbestos crisis of a few decades ago, there will be personal injury claims arising out of this PFAS pollution. And a lot of people, when those personal injury claims come in, will look to their more general liability policies for those for cover for those things. But well before those claims come in, the pollution, the PFAS pollution that's in the ground, that's in water, is going to be the subject of cleanup requirements by regulators. Lots of cleanup can certainly be expected from regulators under those regimes that I talked about earlier. Will general liability policies respond to those cleanup actions? No, for reasons that I've set out, using the Bartoline case as an example, those general liability policies aren't going to cover the costs that are incurred by the regulators or to the regulators for the cleanup. Not only because of the Bartoline principle, but also because so much of that PFAS pollution that has happened over the years won't be sudden and accidental in nature. It'll be gradual. And as Richard said right at the start, gradual pollution is not something that you can expect to be covered under a general liability policy. So PFAS promises all sorts of interesting twists and turns over the from the point of view of pollution over the next few years. Go to the next slide, please. Well, back to you, Richard.
So this is the next poll as well. So
It is.
here we have, so when we're thinking about environmental insurance, do you, having heard the presentation so far, would you consider environmental insurance to be a first party insurance or a third party insurance? And the options in the poll are first party and third party, or a little bit of both. And I think most people have seen. I think when there's an option on a poll that says both, all of the above, it normally is the case.
We've all done it.
Exactly that. So, like we said right at the start, the trigger on an environmental policy is the pollution event, rather than a party making a claim. So the trigger is the pollution. So pollution, sometimes I like to think of it as pollution is effectively the insured peril. So for pollution insurance, they need to get the protection they need. Clients would need to trigger the policy before they receive a third party claim. So one of the key coverages is not only the cleanup costs, but mitigation expenses. If you wait for the third party or the regulatory intervention, the pollution event could be a lot worse than if it was mitigated and emergency response happened earlier in the process. Perhaps mitigation expense could be contained on the premises before it starts to impact and generate third party liability claims. When we look at this, so site-based policies, we have site-based environmental policies are triggered by the pollution event without the requirement of third-party claim. We also talk about contractors' policies a bit later on. Contractors' policies tend to be a bit more third-party in nature because it's that effectively that work where you're always going to be on a third-party site. So I think the next slide kind of summarises this in the 4 M's. So we have mitigation, emergency response, migration, and manifestation. So this is how an environmental policy really demonstrates its difference from property damage and liability policies. We don't need a third party. They can help mitigate and respond and provide emergency response before the third party claim has been received. And although I suppose the important point there is, although it says gradual, not sudden accidental for the manifestation, exactly that, but environmental policies do cover both gradual and sudden accidental. Sometimes we see some queries saying, oh, the environmental policy is only gradual pollution. Well, no, it's kind of all encompassing, if you like. So there on the next page we have, so essentially like we said, there's contractors and site-based policies. Again, in my kind of, the way I like to be able to explain it to myself is we have kind of clients whose main exposure is their premises and their permanent operations itself, and effectively in insurance lingo, work away type exposures where their main exposure is what they're doing on other people's sites. And then
yes, so just to sort of summarize where we've got to after this first section of this presentation, before Richard goes on to talk about some case studies. Hopefully everyone's got the message that there are gaps in cover, depending on in public liability and property policies when you come to talk about pollution. And very clearly, I mean, obviously, when it comes to pollution, you can see from the column on the right-hand side with all of those ticks, that environmental policies, environmental insurance policies are very good at covering all aspects of pollution. The public liability policies and the property policies are very, very limited. You'll see by all of those crosses, very, very limited cover. The public liability policies in particular, because they only cover pollution from sudden and accidental coverage, from sudden and accidental events only. They don't cover gradual incidents. Well, of course, so many incidents are, pollution incidents are gradual, they're not sudden and accidental. They only, public liability policies aren't going to cover the sort of cleanup actions that are required by regulators under these various environmental regimes. But yes, a whole load of things there, as you can see, are not going to be covered by public liability policies. Similarly, property policies, again, a number of shortcomings when you look at pollution and pollution liability risks that an insured might suffer. On the next slide, please. Case studies.
So yes, so I think in kind of training in lecturing is that now let's test our understanding, I think, is the
next slide.
And yes, so these case studies are a mixture of kind of real claims and real clients that have been kind of simplified and anonymized for the purpose of illustration, but is hopefully to help illustrate where an environmental policy is useful and can help clients. And I suppose this first example is maybe one of the most stereotypical environmental type clients, where we look at anybody who has tanks on site or bulk storage of any type of material is the kind of client who really should be thinking about whether environmental insurance should be appropriate. So here we have a petrol station. Over a long period of time, slow movements in the soil creates a hole in the underground pipe that's feeding the underground tank. The small leak was undetected for several months. It creates a plume of oil in the soil, which needs to be remediated. So this is a first-party pollution remediation for £500,000. And this next poll, do you think this was covered by the client's property policy or their public liability policy, or perhaps neither? Exactly. So we have 100% for neither, which is good. Exactly. Yes. It's first part. It's on their site, so there's no third party claim. So it's, and also, like the description says there, it was undetected for several months. So we were not complying with the definition of sudden and accidental, where it's not at a specific moment in time, but equally, as we said, there's no access to a PL policy until you have a third party claim, of which there hasn't been one. For a property policy, you need to have a peril, and there's no insured peril at work here, so the property policy equally would not respond. So I think the next slide just summarizes that in terms of exactly how. So probably yes, gradually developing pollution, no SMA trigger, and exactly, so that's how for a petrol station where the environmental policy can really be useful. Perfect. And then the next one is a beach resort hotel. And we have a few things here. So the client's a large coastal hotel resort. They have a jet ski facility. So again, they have petrol storage on site and a petrol pump for refueling the jet skis. There's diesel tanks for the boilers, there's backup power generation, there's a sprinkler pump power supply as well. There's a basement and they have chlorine and system for the swimming pool, and there's on-site wastewater treatment and collection fee. So in terms of the poll for this one, why do you think this client may be interested in environmental insurance. So perhaps the fuel tanks, perhaps the coastal area, or perhaps the swimming pool. And so I think the poll is showing that, like the first example, most people are thinking about the fuel tanks and exactly that. And that's why I like underwriting, because underwriting, I think, is just about thinking about the right questions to ask and framing the exposures. So I think all of those exposures, depending on the specifics, are absolutely correct. So there isn't a wrong answer on that poll. Coastal area is highly sensitive area. So if you tend to have beach hotels in very pretty parts of the world, and so a very sensitive environment to pollution, where if there is something, there might be a higher requirement to clean it up, to put it back how it was, than if it was somewhere else. We have a variety of tanks on sites for a variety of different things. So there's and if you think about the way you use jet skis, they need refueling a lot. So the more you have to fuel and refuel, the more chance you have of spilling something. And then you have a swimming pool, and with swimming pool comes, again, these kind of tanks and chlorine and chemicals, but also some of those risks of things like Legionella. I think that next slide captures that. Perfect. Awesome. So then we have we have factory, and in the factory we have an old tank which has a large quantity of toxic liquid as part of a manufacturing process. So this tank fails. The pollution flowed through the factory and into a stream near the mill into the sea. The incident led to a 7-week shutdown in the factory with 450 employee factories, with large factory, and it led to a long shutdown while it was remediated. So I think on the poll we have, do we think the property damage, the business interruption policy covered this loss, especially the business interruption, or do you think the public liability provided any coverage, or do we think neither? Also, we have a bit more of a spread on this one. We have a few votes for the property damage policy. We have a few votes for the public liability policy, and a few, and maybe just about half people voting for neither. And I think, like some of the other case studies, the property policy was problematic in terms of demonstrating that coverage was available under the property policy, because it goes back to the peril and the trigger. So the difficulty in identifying the peril, the tank failed. So if the tank failed not for a peril, but maybe because of age or rust. So no peril. I think the next slide captures this. No peril is no coverage. Non-damage BI, and by no means am I a business interruption expert, but for non-damage business interruption, if there is no damage, if there is no peril, non-damage BI extensions normally exclude coverage for if the originating cause of the incident is on the site itself. So without a peril, the business interruption and property policy wouldn't necessarily respond. And then the same issues under the public liability policy, again, the majority of the loss was for business interruption, but again, there's no third-party injury or damage, just off-site cleanup costs. And although it could be argued it's sudden accidental in terms of the tank failure, where you may have that difference is the point Ada made about the difference between property damage and cleanup environmental damage, and whether the cleanup from the toxic liquid going into the stream constituted property damage or not within the confines of a public liability policy. So although an extreme example, we have this one in here because essentially anyone who has bulk storage, oil-fired heating, if you have a country house and you have an oil-fired central heating, if you have diesel generators, you have backup generators for your sprinkler systems, anyone who has bulk fuel storage may be wanting to investigate this kind of environmental coverage.
Well, so lots of situations and lots of businesses obviously are susceptible to pollution risks. And once you've worked out that, you know, as an organisation, once an organisation has worked out that pollution is, or liability for pollution is something that might affect them, you get into and you're thinking about environmental insurance, you get into a whole lot more questions. There are lots and lots of quite complex questions that could arise as to, you know, trying to match what the business does with the potential response of the environmental insurance. And really, it's just to note that it really does pay, if you've got questions about it, to speak to the specialist underwriters and the specialist lawyers about some of these things, because they're the ones most likely to know the answers. Here are, you know, what Richard calls the sort of dirty dozen, even though it's not quite a dozen, but it's a whole. These are questions that, you know, that have come up over the years, the sorts of questions that people want to know, that people want answered in relation to you know, in relation to the environmental cover. A lot of people at the moment are asking about PFAS, for example, and there are an awful lot of things that, you know, there are an awful lot of questions that you might want to know about your PFAS liability, PFAS coverage, that's for sure. The relationship with asbestos, I mean, to what extent do these policies cover asbestos? I mean, it's generally excluded in a lot of insurance policies, but how would an environmental policy, for example, cover asbestos when it's one of the contaminants in the ground? That's a question that comes up. Another question that comes up is, how do these policies cover fines and penalties? Because there are certain kinds of civil penalties that can be levied by environmental regulators that have remediation as an element to them. To what extent do those which do have a sort of remediation element, to what extent might those be covered by environmental policies? So there really are lots of once you realise that, you know, pollution is a risk to which your organisation is going to be, to which an organisation is going to be exposed, people ask all sorts of questions. Here are just a few. And some of the answers do require quite a bit of specialist knowledge.
We've had a question in the chat.
I'd say.
We have, yeah.
So does an environmental liability policy include coverage for legal defence costs arising from regulatory investigations or enforcement actions of the Environment Agency or any other environment authorities?
Do you want to?
Well, I suppose without giving too much of a kind of a politician's answer, quite often it depends. But yes, I think if we go back to the originating cause, the originating trigger of environmental policy is a pollution event. So I think it's important to understand why the Environment Agency or there's regulatory investigations and enforcement actions. If it's because of a client's day-to-day activities and their kind of business as usual, or it's because of an incident and a release of pollution, they've noticed that the river near the factory is demonstrating quantities which are outside what they may have been previously. I don't know if you want to expand on that.
No, that's fine.
Yes. Yes. So yes, it's a complex area, and I think these environmental concepts, as I say, we don't come across these all the time, but the same, this is probably why specialist environmental markets can help, because we see these queries more often than others. And when I overlay it, I think on the next slide we kind of overlay this with the MGA space. So I think about the MGAA, and we try and look at kind of like a menu of how we see environmental product being incorporated into an MGA's product suite. And so sometimes they may have a lot of SME clients who might just need a little bit of extra environmental coverage to supplement their GL. But then we may have MGAs and underwriting agencies who specialize in a specific industry or specific geography. So agricultural waste or motor trade or property owners, these kind of things, where they're looking for an environmental product to specifically address the needs of their portfolio. So environmental can be incorporated in many different ways. So MGA model really helps because it provides the distribution. And I think, like the last slide said, we have kind of centralized underwriting and legal expertise, but what we don't have is the distribution and the reach of an MGA who can reach those clients and to get them the additional pollution coverage they may need, but may not have the contacts or the availability to access it on a normal, traditional open market basis. Some MGAs like to kind of launch quickly with kind of line slips or open market options if they have. Environmental perhaps doesn't quite meet that 80-20 rule of products, in terms of you may only ever encounter one client who really needs environmental insurance, and that's why some of these open market type solutions might work. And then that's the conclusion. So I kind of don't like to think of environmental policies as EIL, because there's a certain amount of first party protection that I think by calling them environmental liability doesn't necessarily pick up. So I think if you only take one thing away, is that environmental liability policies are not just environmental liability policies, they're more pollution policies, providing a significant amount of first party BI cleanup cost mitigation type expense in addition to that third party liability. The MGA model helps the distribution awareness of environmental coverage, and here in London with the specialist knowledge, the Lloyd's market, the learnings that we get from providing this coverage in other countries where the markets are a bit more mature, we can help take those and apply those to the UK market to really build on the awareness of environmental and that headroom of all of these clients that have that current coverage gap. And I think with the learning objective, so hopefully they all now have ticks against them. With that, Alison, I don't know if we had any more questions.
That's we've got the one question that got submitted on the chat, which we've answered, but we've still got a little bit of time. So if there is anyone who's got any questions, anyone that wants to get their own back for joining a presentation where they were asked questions. Like I say, I won't. Rather than make us all sit here in deathly silence with pressuring people. Your contact details are on the presentation, aren't they?
Yes. So on the last page, there's our contact details, and there's also, I mean, the Weightmans website in particular. There's a whole library of past papers and technical insights on lots of different environmental topics.
Yeah, absolutely.
So just having a quick check, we've not got any questions pop up. So I think that that leaves me to thank you ever so much for all your work you
Thank
put
you.
in before and during. Thank you. You've got the record for the most poll questions in a presentation, and thank you to everyone who joined in and shared your thoughts. And you have a thank you come through on the chat.
Oh, perfect.
So
Thank you.
I think unless there's any last minute questions, which it doesn't look like there are, we've given everyone 5 minutes to get themselves ready for possibly their next meeting, which will due start at 2. So yes, thank you everyone for joining, and I'll see you again for another market briefing in the not too distant future.